Hey guys, what's up? Welcome to the fourth installment of the Google class action lawsuit, Damore v. Google. Damore and Guterman. Let's not diminish Guterman's role in this. He's a representative of the class. He appears to be unfairly treated for his political views in the same manner that Damore was. And also for his whiteness and his maleness, apparently. Because I guess that's what we do now, right? Is we determine people's race and gender to be the basis for their employment. That's the progress we've made from the 1950s, when we determined people's races and genders to merit to be the sole merits for their employment. We've progressed right straight back to that. So, allegedly, let's let's clarify some important things. And let's start with maybe the most important thing. And this, people get caught up in this stuff. And I don't mean to make light, right? There are real people involved in this. Their careers have been ended. There are people who feel threatened and afraid. Currently, right now at Google, there are people who feel threatened and afraid. I mean, sure, there are people who are threatened and afraid by people like me, for reading a overtly biased document. Since it's a complaint in a lawsuit, it must be overtly biased. And if I'm reading the complaint to you, it's going to sound overtly biased. I don't know what's going through some people's minds when they look at this stuff, right? Or what's not going through their minds. Because I've stated over and over, this is Damore's complaint. It's written in the light most favorable to Damore. If I'm going to read it line by line, yeah, it's going to look a lot like, this is favorable to Damore, that maybe I'm on the side of Damore. And at this point, let me be clear, I think I am. If I accept these facts at face value, and I currently don't possess information to consider otherwise, then I'm going to be in favor of Damore. That's sort of the logical outcome of reading this stuff without pretext, right? Without me determining what must or must not be true from his factual, from his fact section. If I take this stuff and read it in as neutral light as possible, knowing it's an overtly biased document, going to be supporting Damore. Had Google sued Damore, right? Had they submitted their complaint, as opposed to Damore submitting his, it would be written in a manner most favorable to Google. I'm sure they'd have a completely different fact section. And assuming I could accept and believe Google's allegations and facts, then I would probably be more in favor of Google on the facts. The last video I did, video 3, and this video are covering the causes of action. And this is where the facts are incorporated into statute or into common law, right? One of those two options, or both and, that's fine. We're inclusive here, right? We include both statutes and common law. And this is where we don't take the biases involved in the factual analysis or the factual statements. What we do is we see if those facts fit into a legal conclusion that's alleged in the cause of action section, okay? And so far, assuming the facts are correct, they seem to fit pretty well. That doesn't mean Damore's going to win. It doesn't mean that it's necessarily the correct interpretation of the law. And mind you, I am but a humble rural Minnesota lawyer, right? I am not a California lawyer. I am not proficient in California law. I am I'm not the guy you would hire to do this suit in California. So what I'm doing is I'm doing a small amount of research necessary to kind of unravel the very basic applications of law in California and lay those out to you guys so you have some idea of what's going on. Obviously, there's a lot more to a lawsuit than this. I've stated before and I'll state it again. The purpose of the complaint is to survive dismissal and to survive summary judgment, to move or to win summary judgment, right? Like that's the ultimate goal, is winning summary judgment. But in a giant case like this, the goal is probably to survive summary judgment. For Google to say, yeah, we agree with everything that they said, and it's not illegal. You don't want that to happen. And you don't want Google to win on dismissal saying, yeah, fine, whatever they said is okay, but they didn't actually allege facts sufficient to state a cause of action. So all that tells us, if the facts match up with the causes of action, or appear to, that this is probably a well-drafted document with a significant amount of legal research going in, and it's not frivolous at this point. They at least have presented a good faith claim, and that's a lot to ask in some of these cases. However, right now, in learning a little bit about these laws, I think Google's in a bad spot. Let me be clear on that. And their fact section would have to strongly deny a lot of the alleged facts that Damore has presented. And in strongly denying, they've got to catch 22, because if they strongly deny the material facts, then then the complaint's going to survive summary judgment. They're going to go to discovery, and that's where the case will really be made, right? When you can go to discovery and you can find out how widespread the alleged infection is amongst management and amongst people with hiring and promoting decisions. So let me wrap it back to where I started here. People get wrapped up in this stuff because it's real. It's got real impact on real people. It can devastate their lives. It can devastate careers. Dangerous stuff. And like I said, there are people at Google right now, and I don't just mean the people who are perpetually afraid because they are part of an underrepresented minority. And I don't mean perpetually afraid in a derogatory sense, because apparently, by the mere mentioning of people's names and quoting their own words, they're even more afraid than they already were. Some underrepresented minorities have cause to be afraid. If you're afraid at Google, based on what's written here, I'm shocked that you would be afraid at all as an underrepresented minority. But if you are, that's fine. That's your subjective experience. I'm not there. I can't comment on that. What I can comment on is that there appears to be another group of afraid people, and they're people who agree with Damore. And maybe people who have watched my videos. And it can't be that many. I don't have a ton of views on these things, and that's fine. I'm doing this for my own entertainment and enjoyment. But if you're out there, if you're watching these things and you're afraid for your position because you hold a certain political view, man, I honestly, I feel sorry for you. That's not the proper situation. That's not how our country was built. And a bunch of whiny people trying to get other people fired based on a political viewpoint, as stated above in the previous video, as laid out, that is not actually legal. If they hold that hiring authority, they're not allowed to do that. That's a violation of California law. But it's also just a violation of the general spirit of what it means to be an American. Like, if you don't like what someone says, here's a thought: don't listen. Or just ignore it. Because guess what? If you don't like what they're saying, they probably don't like what you're saying either. But if they're not trying to get you fired, it meant they sucked it up and dealt with it because they had a job to do, and so do you. So get back to it. That's all. But again, going back. I'm sorry. I have a disability, and it's tangentitis. I tangent all over the place. I can't stop it. But the important thing that I was alluding to earlier is I've got a new bottle of whiskey. This has sort of come highly recommended. This is Hibiki. This is a Japanese Harmony blend. The Hibiki 17 has been recommended to me, but I am a lawyer in a small town. So the options on Hibiki are limited to just this. This is the only bottle around. And I will be on a search for that 17 and 21 year Hibiki to try out. But I figured that the 17 came so highly recommended that I am going to try this lovely blend. And if you steered me wrong, I'm going to be pretty angry. But I don't think you did. Smells good. I gotta be careful. My nose is giant, so when I actually nose a glass of whiskey, I might dip the tip of my nose in. So, pardon my caution. It's very good. It's a little harsher going down than I would like. And I bet the 17 year really gets rid of that. It's not harsh, mind you. It's just a little harsher than I prefer. But one more sip, and then we'll get into this mess. It is tasty, though. Thank you. Thank you for the recommendation. I am no longer potentially mad at anybody. I'm having a good time. So, excuse me. All right. So where we left off, we had completed cause of actions 1 through 5. And completed may be a loose phrase, because again, I'm kind of offering a very high level de-scrambling of legalese into some sort of understandable English. Hopefully understandable. But I've been getting good feedback on that, so I appreciate it. I really do take feedback and criticism seriously. I want to provide a video that people want to watch. So if you have some, lay it on me, buddy. You can drop it in the videos comments section. You can send it to you can find me on Facebook and Minds and Google or Gab and everywhere, Twitter. Just yell at me. That's cool. I'm with it. Anyway. Also, if you have an employer and someone has shared this video and it hurts your feelings, please tell me about that too. I get no joy in being the bad guy. So, the 6th cause of action. Let's jump into these. We've got 5 of these causes of action left to go. And then we're going to finish this document. And one final announcement, as I'm now 15 minutes into my introduction. I'm so bad at brevity. Tomorrow night, tonight, I guess. It'll be Friday, January 26th, 2018, 10:30 p.m. Central. I will be doing a live video on this on this lawsuit, we're gonna go through in the background Damore's memo. It's the first exhibit. And then if we get through Damore's memo and still are not too, like absolutely hammered from all of the drinking and camaraderie that will occur, we will go into further exhibits. But I will encourage people to ask any questions, I guess, in regards to the lawsuit, but really anything. Because answering questions is just a fun thing to do, and I love to interact with the chat. So please stop by the live streams. The ones I've done in the past have been pretty fun. So come on, ask me questions. I will attempt to answer them, derail the topic, make it chaotic and great, and we'll just have a good time for 2.5, 3 hours. Who knows? However long it takes to have some fun, because having fun is something that so many people have lost the ability to do today. Just find something fun and do it. Oh my goodness. If it's coming onto a live stream and telling me that my nose is giant and I'm a stupid idiot, please do it. If that makes you happy, do that. And I'll call you an idiot and we'll have a good time. It'll be great. Anyway, let's get into these causes of action. And I had a friend of mine send me some research to kind of cut down on the stuff that I have to do, because I am still a lawyer, right? I have my own practice that I have to keep up with as well. And this friend of mine has graciously offered some time and just helped me pull together some of these citations so that I can help, kind of explain what's going on here. So this is retaliation in violation of public policy, and Tammany is a case that they're kind of referring to here in this cause of action. So the plaintiffs repeat and incorporate each paragraph above as if fully set forth here. Right. Reprimanding employees in retaliation for resisting the violation of laws that secure important public policies contravenes those policies and gives rise to a common law action in tort. Okay, so what they're talking about, this is from Glenn versus Clearman's Golden Cock Inn Incorporated, which is maybe, it's a fantastically named hotel. I have no idea what this hotel specializes in. But I have I have my suspicions, I guess. But anyway, so this is a violation of public policy. If you have an employment policy that violates public policy, you're technically opening yourself up to civil liability. That's the claim that's being made in the Damore complaint. And here is the public policy. It's right here. In this head note. The public policy of this state is declared as follows. Oh, excuse me. It is necessary that the individual workman have full freedom of association, self-organization, and designation of representatives of his own choosing to negotiate the terms and conditions of his employment, that he shall be free from the interference, restraint, or coercion of employers of labor or their agents in the designation of such representatives, or in self-organization, or in other concerted activities for the purpose of collective bargaining or other mutual aid or protection. So this case is about a group of people who wanted to unionize, and they were fired for wanting to unionize. So ultimately, this is not directly applicable to this case, other than the idea that Here we go. In part, any person or agent or officer thereof who coerces or compels any person to enter into an agreement, written or verbal, not to join or become a member of any labor organization as a condition of securing employment or continuing in the employment of such person is guilty of a misdemeanor. So this case is not directly relatable, right, to the Damore case, because Google is not a union shop. We don't have any labor issues. involved. Labor with a U if you're not from the United States. We don't have any of those issues here. And so, but what we do have is the idea that it's illegal to prevent people from unionizing. That's against the public policy. We want to allow people to unionize in California, right? Typical communism would be to allow unions and labor unions because those are just fine. But if we're going to allow people to unionize and then you try and do through the freedom of contract, you try and say, I will offer you employment on the condition that you don't unionize, then that contract is opposed to public policy and is voidable or presumptively void, however you want to look at it. Really doesn't matter. The contract is unenforceable. The state, like if you, as the employer, like you say, no, you can't unionize, and they say, okay, and then they unionize, and then you take them to court for breach of contract, the state court cannot enforce that provision of the contract. Therefore, they'd have to void it. They have to say, no. It's contrary to public policy to allow this sort of contract. So that's the main thrust of the Golden Cock Inn case. Here they conceded that their employments were at will and could be terminated by either party. But importantly, this rule is modified by an exception that prevents a contract of employment at will from being terminated where the reason for termination is one which violates established public policy. So that's what's going on here. And that's where, Damore doesn't cite this case, but that's a useful case to look at for it. Here's the actual case that Damore cites. This is Temeni versus Atlantic Richfield Company. Under traditional common law rule codified in Labor Code Section 2922, an employment contract is of indefinite duration is in general terminable at the will of either party. You can't have a contract. Well, when you have a contract of fixed duration, it ends at a specific time. If it's not a fixed duration, you're not obliged to uphold it for a specific duration. But importantly, under both common law and the statute, an employer does not enjoy an absolute or totally unfettered right to discharge even an at-will employee. There are restrictions. This is citing Peterman versus International Brotherhood of Teamsters. It imposes a significant condition upon the employer's broad power of dismissal by nullifying the right to discharge because an employer refuses to perform an unlawful act. So here's where they're going. Let's see how this plays out, and let's see if we can figure out if the facts alleged match up with the cause of action here. I read 255, 256. Plaintiffs were given verbal and written warnings after complaining about Google's unlawful hiring and promoting practices. Google's violation of plaintiffs' statutory and constitutional rights is inconsistent and hostile to the public interest. So if you go and tell your employer that they're doing something illegal and they fire you for it, that's contrary to public policy. If they retaliate against you, there's, you can't do that. And we're going to talk about why you can't do that in some of these other causes of action. But this is a common law retaliation. And so by invoking Temeni, they're saying that the provisions of Temeni, which again, let's see. In Temeni, the plaintiff refuses to violate the law and suffered discharge as a consequence of that refusal. Temeni was being asked to engage in price fixing, and he refused to do so, and so he was discharged. Again, this is not directly comparable, right? Because we don't have Damore being asked to engage in an unlawful activity necessarily, because we don't have any indication that Damore was a team lead or had hiring or promoting authority. of any sense. But if Damore is not allowed to raise the specter of unlawful conduct without retaliation, then that's a violation of public policy, because whistleblower protections exist for this very purpose. They want company employees to be free to share their discomfort with their employers. And interestingly, in Damore's case, him stating, hey, I think Google has an unlawful hiring practice here, okay, or an unlawful promotion procedure, or unlawful transfer procedures based on unlawful discrimination based on race. Him saying that has nothing to do with his ability to perform his job. And we're not given any indication that his statement somehow impacted his performance. And I personally struggle to see how they would. He's a software engineer. He's voicing an opinion that says, based on how I look at this statute, it seems to be illegal what we're doing, and here's a different way to go about meeting the goals but not violating the law. Now, the HR team and the legal team are free to disagree with Damore, but to reprimand him for doing so, that's where the problems really come in. Because how does his statement that we may be committing an illegal act merit a reprimand? What does it matter in the course of his business duties? Is he somehow deficient because of this? And let me note that, if you're saying that he's taken too much time to write this memo or whatever, first of all, the memo's not that long. We don't know if he wrote it on company time or personal time, but it doesn't really matter, because as far as I can tell, no one at Google has any time to work, because they're always at a workshop or reading a message board or going through, newsletters and email chains. And it's a circus. Like, as I'm reading this, I don't even understand how this business functions and gets anything done, because it seems like someone is always doing something that is not work. But I don't know. Maybe they're just very efficient and effective people. And maybe part of that is, I'm jesting, obviously, but maybe part of that is the environment that Google fosters, where they're encouraging learning and these exploration of these other topics. Ostensibly, Damore would contend that maybe certain topics are off limits, but maybe the fostering of this learning and exploratory sort of environment allows people to work more efficiently, because they feel free to go ahead and look at other avenues. I don't know. I'm not Google. They seem to be doing some things right. They're making good money, hiring lots of important people. So people who get fired. That's good. That's good stuff. Okay. Let me finish with Tammany here. In support of its contention that an action for wrongful discharge sounds only in contract and not in tort, ARCO argues that because of the contractual nature of the employer-employee relationship, an injury which an employer inflicts upon its employee by the improper termination of such a relationship gives rise only to a breach of contract action. California decisions, however, have long recognized that a wrongful act committed in the course of a contractual relationship may afford both tort and contractual relief. Tort is personal injury. Not necessarily physical injury. Could be economic, could be emotional, could be all sorts of things. But that's property damage. A tort is a personal injury. Tort and contractual relief, and in such circumstances, the existence of the contractual relationship will not bar the injured party from pursuing redress in tort. In invoking Tammany, they're trying to head off some of the ideas that where Google would say, no, this isn't a personal injury claim or civil cause of action. This is a contract claim, and contracts have different remedies than other torts. They may be limited to equitable relief. Equitable relief would be where the court says, sure, this party's right, this party is wrong, but this party performed a certain amount of services, so you got to pay them something. You can't just get out of paying, for example. Maybe you can modify the amount that you have to pay, but you still have to pay something. Equitable relief tries to find equity between the two parties. Torts do not tend to fall into equitable relief. Torts tend to be, relief specifically for the victor. So they're trying to keep this out of the idea that there's equity, and they're also reinforcing the idea that asking employees to be silent in the face of illegality, and then reprimanding them for internally voicing their opinion is a problem. So Google's arguments for reprimanding plaintiffs are pretextual in nature and calculated to disguise the motivating basis of the adverse employment action to which plaintiffs were subjected. This is going to be, I believe, mostly applied to Gudeman, who received negative performance review right away. It was indicated that he was probably going to get a positive or at least satisfactory performance review, received a negative performance review right after making statements about the hiring and promotional processes at Google and the discrimination that he believed was occurring. So what they're trying to do is set up a counter argument right from the get-go. It says Google's going to come out and say that these guys were reprimanded for these legitimate reasons, blah, blah, blah. But that's all a pretext. That's a sham. It's a shamocracy, where Google is just trying to cover up its illegal activities. And, if they get to discovery, especially, that'll be an important part. So they're setting up, going back to that whole complaint surviving summary judgment, setting up every paragraph in your complaint to be a point where the other party has to disagree, and that disagreement matters to the case, is how you survive summary judgment. You have to have genuine disagreement over issues of material facts material to the causes of action, to survive a summary judgment hearing or a summary judgment ruling. And in this case, they want to get to discovery, because discovery means probably that they win. Even if they don't go to trial, if they survive summary judgment and go to discovery, it's going to be extremely expensive and embarrassing for Google. It would be embarrassing for any major company to have their internal communications laid bare to the world. It just would, because giant companies employ all sorts of people, and some of them are going to be terrible. Statistically, they'll be terrible people, and having that laid bare for the world to see, they don't want to do it. Taking this in a light kind of sympathetic to Google, Google probably doesn't want the conservative employees that they hire, their views voiced, because they may not toe the typical line that Google seems to be promoting. They may not promote whatever notion of inclusivity that Google has. They may disagree with that. And to have that laid out there in a court document for the public to view could be very damaging. Okay? So, surviving summary judgment, this statement is here to help them survive summary judgment. Because Google is obviously going to disagree. They're going to say, no, we legitimately reprimanded these guys for other actions which are laid out in all of our HR documents that are well curated and categorized right here. They're saying, no, we disagree from the onset. So direct and proximate cause of Google, or result of Google's willful, knowing, and intentional retaliation, they suffered all sorts of damage. It was malicious, and then you can get attorney's fees, punitive damages, and compensatory damages. Okay, same as before. That's a copy pasta every time. Those last three paragraphs are basically the same in every cause of action. Seventh cause of action. So this is retaliation, and this is not a common law retaliation, right? The first one was common law. It's relying on the way that California courts have ruled in cases. That's common law. This is a statutory retaliation. Retaliation in violation of California Labor Code 1102.5. So the plaintiffs, let me close these. These are not useful. Oh, wait, I'm sorry. Let me go back because this is relevant to both of these causes of action. I've got the facts section pulled up here. And this is important because there seems to be, as I see chatter about this case, there seems to be some confusion. Damore didn't leak the memo or publish it publicly. Damore didn't even publish this just on a random chat group at Google. According to the facts section, and we may get alternative facts from Google, right? Funny, like, brief tangent. The alternative facts thing from Trump, which a lot of people were just appalled by the idea that there might be an alternative set of facts to a given event. Like, how dare they? If you're a lawyer, like, you deal in alternative facts all the time. Two different people look at situations very differently. And you may have all sorts of disagreements with what Trump was talking about. And I think that was in regards to, or not Trump, but whoever was answering questions to the press that day. Conway, was it Conway? She came up with the alternative facts statement. And I think it was in regards to the inauguration attendance from Trump, for example. Okay, so you may disagree with that thing. But the idea of alternative facts, like you engage in alternative facts constantly. So stop being so smug about the statement about alternative facts, because everybody has a different perception on the events that occur. Some people think that in my previous videos, I was calling for violence. That would be an alternative set of facts to what my perception of the set of facts were, because I didn't call for any violence against anybody. I actually don't advocate political violence. And if you're referring to the part where I said they make me want to punch someone in the mouth, yeah, having some sort of gut reaction to the horrendous disdain for humanity that some people possess is not the same as me calling for someone to be violently attacked. I last I checked, my arm does not reach like 7 states away. So I don't have the ability to punch any of these people in the mouth. And having a guttural reaction to their, as I stated before, their just disdain for humanity. Like, sure, I want to punch a lot of people in the mouth, but I don't. I don't punch people in the mouth, and I don't advocate people being punched in the mouth. The question is, for you again, you who were worried and concerned about my violent rhetoric, have you advocated punching a Nazi? And if you have, maybe you should evaluate either your statement or mine and determine what is meant by those statements. If you think I'm calling for violence, yet you have advocated for punching a Nazi, then maybe you're calling for violence. And if you have advocated punching, or if you, I don't know, I don't even know where to go with this. If you think that that your statement of wanting to punch a Nazi is not violent, then maybe I wasn't calling for violence either. And we can have a laugh over the fact that I was so triggered by the idea that people hate themselves so much that they reduce themselves to a particular narrow identity. And they think that that is the most important aspect of their being, to the point where that's where they derive their worth. My reaction to that is to say, I wish you realized that you were more than just this narrow slice of thing that you're identifying with, and that you have merit beyond that. And the fact that you hate yourself that much makes me want to punch you in the mouth. If you think I'm actually like calling for violence on that, reevaluate your life. And by the way, stop identifying so narrowly whatever skill set you bring, because that statement either was a precursor or or an epilogue to my rant about the value that any given person can bring to just about anything, because someone has something of value to offer. And not someone, everyone has something of value to offer. And go offer it, and stop assuming that you're being given a speaking position based on this narrow facet of identity. That's such a small spectrum of who you are. Go be better than just an identity. Go be something that people want to learn from because you have knowledge, not because of what you identify as. That is a disdain for humanity, and I still hate it. I still hate it. I don't care how you identify. It doesn't offend me that you identify in a certain way. What offends me is that your identity is the extent of your being, and I'm basing this solely off of the evidence provided earlier in this complaint, which states that which insinuates that a woman would only be offered a speaking role because she was a woman, not because she had something to speak about that people would benefit from hearing. That's offensive to me, because you're reducing someone to a gender identity and nothing else, as if that's all that matters about them. And that's disgusting. Learn about humanity. Anyway, tangentitis, right? That was a huge tangent. I apologize. So Damore submitted this memo to Google HR. He didn't submit it publicly. It wasn't on one of these circle chats or a G+ group or something like that. He didn't tweet it out and say, look what awful thing Google is doing. He used the feedback form provided by the summit that went to HR. And he said, here's my memo. My memo consisting of this research, which I have cited and hyperlinked for you in the memo. Please look at it, because I think maybe something's wrong here. That's what he did. That's what he did. Everything else was done by someone else. And it's important to keep that in mind in these talks about retaliation, because it's one thing to say Damore went on the alternative right talk circuit. He went on Tucker Carlson and called out Google's unlawful employment practices, and that makes Google look bad. That's disparaging to the business, and that gives them grounds to terminate. No, he went through the proper channels. And as we tend to find in pretty much any whistleblower thing, and this is why those laws exist, when people go through the proper channels, they're either ignored, reprimanded, or fired. Ask Edward Snowden how the proper channels worked out for him. Damore didn't even go outside of Google. Some other person linked bits of it to Gizmodo? They're Gizmodo, that's a non-biased, wonderful source. Anyway, getting back to it. Section 1102.5, California Labor Code. In pertinent part provides, quote, an employer or any person acting on behalf of the employer shall not make, adopt, or enforce any rule, regulation, or policy preventing an employee from disclosing information to a government or law enforcement agency. Not relevant here because we don't have any facts stating that Damore went to a government or law enforcement agency. Here's where it becomes important again. To a person with authority over the employee, or to another employee who has authority to investigate, discover, or correct the violation or non-compliance. Damore submitted this to HR, right? Eventually, he posted the memo on a Google group discussion forum called Coffee Beans, used to discuss various issues at Google, such as workplace diversity. And Damore emailed individuals responsible for Google's diversity programs, Women at Google program, Code of Conduct team, and Google HR. These are people, right? Sorry, here we go. Whoa! Clicking all over the place. These are people, presumably, who have the authority to investigate, discover, or correct the violation or non-compliance. HR would have that. Legal would have that. These groups that specifically exist to discuss diversity would at least have the authority to investigate diversity issues because they'd want to bring them up. And if they're not the people who make those decisions, then they would know the channels to elevate them too. It appears that Damore followed all of the presumed chain of command, right? But I don't know. I don't work at Google. Again, I'm going off the facts that I've been given by Damore. When Google files their response, they'll have the opportunity to contest against this and say, no, Damore completely violated our policy for reporting these things. And at that time, I may change my opinion. Who knows? New evidence. We'll see. I don't have Google's answer. I don't think they filed it yet. But I'm watching and hoping that it comes out because I would love to see how they answer this stuff. Anyway, sorry. Or to testifying before any public body conducting an investigation, hearing, or inquiry if the employee has reasonable cause to believe that the information discloses a violation of state or federal statute or a violation of or non-compliance with a local, state, or federal rule or regulation, regardless of whether disclosing the information is part of the employee's job duties, blah, blah, blah. Labor Code 102.5 subsection C and D provides an employer or any person acting on behalf of the employer shall not retaliate against an employee for refusing to participate in an activity that would result in a violation of state or federal statute or a violation of, or non-compliance, blah, blah. And that's section C. D is an employer or any person acting on behalf of the employer should not retaliate against an employee for having exercised his or her rights under section A, B, or C in any former employment. Pretty straightforward. But let's see what this statute says. They don't, they talk about Part B and C and D. They don't really talk about Part A. The employer may not make, adopt, or enforce any rule or policy preventing an employee from disclosing information to a government or law enforcement agency or to a person with authority over the employee. By reprimanding people who report these violations, by reprimanding them, you're at least giving the appearance of implementing a rule, regulation, or policy to chill the speech of employees and to prevent them from disclosing this information. You may not think you're doing it, but you are, especially if it becomes a pattern of behavior. Patterns are bad for employers. They're good, but patterns of bad things are bad. There's a tautology for you. Patterns of bad things are bad. Okay. As set forth above, plaintiff opposed the wrongful and illegal practices by Google in regards to Google's practices of discrimination, harassment, and retaliation of individuals based on their protected traits. And remember, in California, political affiliation and association is a protected status. That's mind-blowing to think of California protecting political affiliation in that way. Because we don't, the stuff that we hear about from California is usually consistently left-leaning. Sorry, you just are. But it's consistently left-leaning. So the idea that it's a protected class in California to be a conservative or a Trump supporter or a libertarian, so long as you're not advocating the overthrow of the United States government, that's a protected status, that's amazing. Like, you can seriously support Gary Johnson and not be fired for it. Almost surprising. Or Jill Stein. Or pick your breed of crazy, right? Like, you could have been the one guy who voted for me. That was me. Terrible. Terrible choice in president, I think. Not really. I actually think I'd be a great choice in president, but my vote was unlikely to produce a good result. That was the problem there. As set forth above, plaintiff... Oh, wait, I read that already. Thereafter, Google took a series of retaliatory adverse employment actions against plaintiffs, such as giving them poor performance reviews and denying them promotions. And if you remember, Damore had According to this fact section, nothing but fantastic reviews up until the moment he opened his mouth. So that might be problematic. Yeah. So then we've got the compensatory damages. We've got punitive damages. We don't have attorney's fees here, so this section must not allow for attorney's fees. 8th cause of action: failure to prevent discrimination. Let's get rid of that 7 there. At all relevant times. So this is a plaintiff's. And if you notice, these are not their class actions, right? These are plaintiffs' individual actions, just Damore and Gudeman. Not necessarily incorporating the classes. The classes were last incorporated in the 3rd cause of action. Now these are the specific facts alleged against Damore and Gudeman. So at all relevant times, Google was required but failed to take all reasonable steps necessary to prevent discrimination, harassment, and retaliation under Government Code Section 12940K at SEC. Let's look at that. So here's 12940. And I know they mention K, but let's take a look at what the statute says up front here. The preamble here is, it is an unlawful employment practice unless based upon a bona fide occupational qualification or except where based on applicable security regulations established by the United States or the state of California. And we have A highlighted here. Let's go through it. This isn't what they're alleging in this. They're talking about K and everything after, but I think we can. It does not hurt to look at this for an employer, because so this is wrong. Google, this is wrong. People at Google, management at Google, this is wrong. For an employer, because of the race. Race, by the way, includes Caucasian, just so you know. Religious creed. Color. Religious creed would include Christianity. Color would include white. This may be news to you because you might not have been taught that this stuff is true. National origin would include America, by the way. Ancestry would include British, French, Polish, Finnish, Norwegian, German, Italian, as hard as that is to imagine. Physical disability, mental disability, medical condition, genetic information, marital status, sex, and gender. So, biological sex, gender, which, because they include gender identity, I'm going to assume gender is perceived gender, right? Like if I look at someone and think that they're a boy, but they identify as a girl, I can't discriminate based on my thought that they're a boy or their identity as a girl. I can't do either one. Gender expression, which is, I guess, not identity. I can make a lot of jokes about this, but basically California is trying to be thorough in their construction of this statute, right? So their gender that is perceived by others, the gender that they identify within, and then the gender that they express outwardly. These can, according to people, be different things. And that might be news to some of you. Not everyone is high on the gender learning curve. And let me talk about the gatekeeping of gender identity and academic discussions on this topic, right? And not just this topic, but every topic. This is something that pisses me off. I was talking to my friend about it today. For you gender studies activists, majors, graduates, I don't know, whoever you are, the pejorative SJWs out there, you have created a system in which the average person working through their average day that doesn't encounter the small percentage of people that have what would be deviate, not deviant, right? Deviate sexual identity or gender identity or gender expression. Okay? So you guys have created a lexicon that is inaccessible to people who have not like gone through some college course explaining the terminology and don't have time to keep up with it. That's fine. But then to exclude the opinions of people who are not up on the lexicon is not fine. That's not an okay thing. You don't get to create an inside baseball club and then exclude people from having an opinion based on their inability to discuss inside baseball. An opinion isn't invalid simply because someone hasn't boned up on the draconian lexicon that you've created, okay? So when some person who's like 58 and has been working their entire life doesn't know what cis heteronormative culture is, like, you don't get to exclude them from having an opinion on sexuality or gender identity just because they don't adhere to your rigid Nazified lexicon, right? And it's not just you. It's not just you. This is done all over academia. We create these little realms of perceived expertise built on echo chambers that rely on these lexicons to exclude contra opinions. And that is intellectually dishonest. So get over your lexicon. Get over the fact that some people haven't spent their lives researching this because they just maybe like haven't had occurrence or occasion to do so. It says nothing about their opinion of you or your identity so much as it does about their just lack of encountering your opinion or your identity. Okay? Get over it. Sorry, that's a personal rant, and this is elitism. Okay? This is, again, not limited to gender studies. It's just kind of relevant in the context of this lawsuit. But creating an elitist lexicon to exclude the contrary opinions of people who maybe aren't up on the lexicon is intellectually dishonest. It's an echo chamber. You need to get over it. No matter what academic field you're in, stop it. Stop it. When you go on these talk shows and you have your smug appeals to lexicon, maybe that should be the fallacy. Appeal to lexicon. Just go away. You're invalidating your own arguments, and you don't even see it, and that's the sad thing. Sorry for that. Anyway, age, sexual orientation. So this is the homosexuality or sexual preference. I guess, heterosexuality, by the way, is also a sexual orientation. Some people tend to forget that. Or military or and veteran status of any person to refuse. So all of that. It is wrong for an employer because of these reasons to refuse to hire or employ the person, or to refuse to select the person for a training program leading to employment, or to bar or discharge the person from employment or from a training program leading to employment, or to discriminate against the person in compensation or in terms, conditions, or privileges of employment. When you state that you have a blacklist against people of these certain conditions, that's wrong. That's not okay. That is illegal in California. As shocking as that may be to you and to everybody else, that is illegal. So Section C. For any person to discriminate against any person in the selection... So this only applies to people, apparently. And like... I'm going to keep a straight face through this as best as I can. Because again, I have no judgment against how people identify. Great. Do whatever you want. This is America, Jack. Free country, right? But if you don't identify as a person, but as one of the people listed in the lawsuit here, or not listed, but alluded to in a footnote, identifies as an ornate building, does this statute apply? Like, I don't know. I don't know. I honestly don't. And that's the weird thing. We may get to a point. Okay, I do know. Yes. Yes, it applies to them. It applies to them. A building is not allowed to discriminate against people, and people are not allowed to discriminate against buildings, except buildings that they find ugly. I guess they don't have to go in them. Or if a building is dilapidated, I guess we can condemn it. Joking aside, currently, even if you identify as a building, you are still a person under the law. Although I don't know how long that will be. Like, if we continue down this road of presumptive acceptance of identity and pronouns and stuff, at some point they may need to rewrite these laws, or to clarify that person includes people who identify as non-sentient or otherkin. There are people who identify as animals, for example, and those people would, I don't know if they would find offense at being labeled as persons. If you are otherkin of any kind, other than human, right? Other than people, other than person, please leave me a comment and let me know, like, is it offensive for a law to determine you to be a person? And do you have like a preferred solution? Should we say person or entity? Like, what would that be? Like, genuine question. If there's anybody out there watching this, please let me know, because this type of stuff is fascinating. Frankly, it's absolutely fascinating to me. So yes, sorry. For a person to discriminate against any person in the selection, termination, training, or other terms of treatment of that person in any apprenticeship training program or other training program leading to employment, an unpaid internship, or other limited duration program to provide unpaid work experience for that person because of race, religious creed, color, national origin, ancestry, physical disability, mental disability, medical condition, genetic information, marital status, sex, gender identity, gender expression, age, sexual orientation, or military and veteran status of the person discriminated against. And let's look at one of those things that I didn't cover before, but genetic information. Because there are suggestions, right, that conservatism or liberalism is genetic or an inherent trait, and that people just can't help it. Is that protected? Maybe. Not yet, but it might be. And if we provide more of these studies, friends, are a double-edged sword. If you provide a study that says that conservatism is a genetic disorder, eventually all of the disabled conservatives will have special protections that you probably didn't want them to have. So maybe think through these things before we go saying that a political position is somehow an inherent trait. Okay, so H. H is not referenced in this section, but I do believe it is referenced elsewhere. And I'm not going to spend time trying to find it. Just take my word for it. And my word is now influenced by whiskey, so take it with a grain of salt. For any employer, labor organization, employment agency, remember, this is wrong things to do. It's wrong for any employer, labor organization, employment agency, or other person to discharge, expel, or otherwise discriminate against any person because a person has opposed any practices forbidden under this part, or because the person has filed a complaint, testified, or assisted in any proceeding under this part. So saying that it's illegal to discriminate against Caucasian males to HR and then being retaliated against is illegal. So this part becomes relevant. They don't actually cite it here. They cite K, which we'll go to. Excuse me. We'll go to K in a minute. But it's cited here. An entity shall take all reasonable steps to prevent harassment from occurring. Loss of tangible job benefits shall not be necessary in order to establish harassment. So you don't actually have to cause economic damage to someone to harass them in the employment setting. And the entity, which would be an employer typically, shall take all reasonable steps to prevent harassment from occurring. Whoops, where are we? K. Woo. All All right. It is wrong for an employer, and I apologize for how tedious this gets. This is a lot of repeated language, but they really, really want to hammer it home. So this is Section K. For an employer, labor organization, employment agency, apprenticeship training program, or any training program leading to employment, to fail to take all reasonable steps necessary to prevent discrimination and harassment from occurring. Oh, excuse me. For an employer or other entity covered by this part to refuse to hire or employ a person, or to refuse to select a person for all this stuff, or to bar or discharge a person, or to discriminate against a person in compensation or in terms, conditions, or privileges of employment because of a conflict between the person's religious belief or observance and any employment requirement, unless the employer or other entity demonstrates it has explored any available reasonable alternative. Blah, 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 blah. K is a weird section for them to cite. Okay, so K is talking about religious observance and religious beliefs conflicting with laws. I don't necessarily think they meant K. Et sec usually means the things that follow. I think they mean, and maybe they'll have to amend this. I don't know. This could be a problem in drafting. Okay, and being honest and fair. This appears, and maybe I'm missing something, but this appears to be a mistake in drafting. They cite K. I think what they mean is H or I to be the specific things, or A, right? Like all of the sections that we went through apply to this case, but for some reason they cite K. I don't know. Maybe a drafting error, maybe a typo. Oh, excuse me. Could be damaging to their case, but probably not, because if a judge brought up that it was a problem, they could probably move to amend it and correct the move to amend for a clerical correction. Anyway, upon information and belief, Google's lack of any meaningful investigation into plaintiff's complaints of coworkers' discriminatory, harassing, and retaliatory behavior constituted failure to prevent discrimination under the Fair Employment Housing Act. Copy pasta. We want also all of the damages. This one allows costs and fees as well. All right. Ninth cause of action. Unfair business practices. These are, I will say that the first couple causes of action are really strong. And they do tend to peter out and get less and less likely and applicable. Oh, excuse me. The overt discrimination that we have in the facts section really tends to look like it's against conservative or right-leaning political opinions, okay? Specifically affiliation with Donald Trump, or a disagreement over gender politics, gender identity politics. Those tend to be the things that look like they're overtly discriminated against. Caucasian male, I think, is discriminated against, but it doesn't appear as blatant to me. This is my read of it, and other people may disagree. Absolutely, go ahead and disagree. But it seems like the causes of action are getting a little weaker as we go, to me. And that's normal. Like, you lead with your strong hand. You tend to finish with a strong hand, and we're going to get to that declaratory relief in the next section. But the first here is the ninth cause of action. This is unfair business practices. Oh, my goodness. I got to do these earlier in the day. This is a catch-all statute. 17-200. Let's take a quick look at it. Here's the definition. As used in this chapter, unfair competition shall mean and include any unlawful, unfair, or fraudulent business act or practice, an unfair, deceptive, untrue, or misleading advertisement, and any act prohibited by Chapter 1. So, looking at what that is, here's how courts have determined this. In determining whether a particular business practice is unfair, under 17-200, the court must weigh the utility of the defendant's conduct against the gravity of the harm to the alleged victim. This is a balancing test. These are very common in legal analysis. We balance the interests of one party against the interests of the other. And sometimes, if an interest is strong enough, we override the presumptively legal outcome. You see this a lot in eminent domain, right? Where if it would be wrong to take the land of a homeowner and give it to a shopping mall, what is this, Kilo? The case, Kilo? For my law nerds out there, correct me if I'm wrong, but I think this is the Kilo case that I'm thinking about, which is an eminent domain case from 2004. Stretching back to my property class, which had a lot of shut-eye involved. If it was Kilo, and if I'm right on this, basically that was the first case in which they took property from private owners and gave it to another private owner. Rather than having a government use, they determined that a public use would be served by someone creating a shopping mall or a strip mall or something like that. And so they, part of how they got to that was they said that the economic value of this shopping center was higher than the residential use that it was being used for at the time, and they were able to justify this taking of some people's homes to pass it on to a private entity under the auspice that it would have an economic boom for the community. It would bring more people in, it would create jobs, and that would overall have an economic balancing effect that outweighed the infringing on people's rights. That was a wrongly decided case. Property rights should be the nearest thing to sacred as possible. That's what the founders intended. Good job, Supreme Court. I think that was Kilo. Anyway, so excuse me. So the next note we have here: the legislature apparently intended to permit courts to enjoin ongoing wrongful business conduct in whatever context such activity might occur. And then unfair competition has been broadly defined. It includes unlawful business activity, i.e. anything that can properly be called a business practice and that at the same time is forbidden by law. Legislature intended to permit tribunals to enjoin ongoing wrongful business conduct in whatever context such activity might occur. This is a catch-all statute. They're doing illegal things, and illegal employment practices would be an illegal business practice, presumably. That's what the argument is here. So what they say is Google's violations of the California Labor Code and California statutory and common law and other provisions as described above in the causes of action listed in this complaint all constitute unfair and unlawful business practices pursuant to Business and Professional Code Section 17200 et sec. The unlawful conduct described herein resulted in harm to the plaintiffs in the class. Because it's ongoing, there's no indication that either Google will cease their unlawful conduct described herein. Plaintiff and the classes and subclasses request that this court enjoin Google from further violation of California laws. So looking for injunctive relief here. Injunctive relief is where the court says, stop doing this specific thing. Stop discriminating against white males who voted for Trump in this case, right? 10th cause of action, declaratory relief. And again, we're back to the 9th and 10th cause of action. We're back to including the classes, not just Damore and Gudeman, but also everyone similarly situated at Google. Which would be white racist hate mongers. That's a joke. It's a joke. Okay. So this is for declaratory relief. Declaratory relief comes in, let's get rid of that, under 1060 here. This is a wordy statute. So I'm going to read these little subsections. No, I'm going to read the whole thing. Sorry. For my listeners who are not watching this video and can't read it on the screen, bear with me. I apologize for the length of this. Blame California, as I blame California for most of everything. Any person interested under a written instrument, excluding a will or a trust, or under a contract, or who desires a declaration of his or her rights or duties with respect to another, or in respect to, in, over, or upon property, or with respect to the location of the natural channel of a watercourse may. So any person interested under a written instrument in all of those things. So in this case, an employment contract, or having employment rights and duties with respect to another person. They may, in cases of actual controversy relating to the legal rights and duties of the respective parties. In this case, there is a right to, a right to report violations of law to your employer. There's a right to engage in political activity. It's created under statute in California. We covered this earlier. There is not a particular right to be employed, but there is a right to have your employment that does exist preserved when the destruction of that employment is an unlawful act or is an act contrary to public policy. Okay? So there are rights and there are duties, right? Google has a duty to prevent harassment that's established by statute. We covered it earlier. So in cases of actual controversy relating to the legal rights and duties of the respective parties, a person may bring an original action or a cross-complaint in the Superior Court for a declaration of his or her rights and duties in the premises, including a determination of any question of construction or validity arising under this instrument or contract. He or she may ask for a declaration of rights or duties, either alone or with other relief, and the court may make a binding declaration of these rights or duties, whether or not further relief is or could be claimed at the time. So they're asking, invoking this statute, they're asking the court to tell Google to stop doing illegal things. And not only that, they're asking the court to tell Google what it is illegal for them to do, and to specifically stop doing that. Stop maintaining blacklists of people who possess, a certain political view that you disagree with. That's it, because that's illegal. It is illegal as a hiring manager to maintain a blacklist of people based on their political views in the state of California. That's pretty clear from, you just watched the last video. It's pretty clear. Anyway, so that's what they're asking here. Okay? So here's what they state. An actual controversy has arisen and now exists between the parties relating to the legal rights and duties of the parties as set forth above, for which plaintiff and the subclasses desire a declaration of rights. And this is mostly the subclasses, right? They want the court to say, Google, you can't discriminate against these guys. Because the moment then that Google fires a white, conservative, Trump-supporting male, now Google's got a problem. They have to then support that with a reasonable, justifiable cause for termination. Because if they've been told that they can't fire white males with a certain political viewpoint, then they do, they have to have a good cause for it. So, it just makes the burden higher on them. It provides some job security for people, and it would allow them to speak more freely or to speak at all. I have been contacted by Google employees who do not say anything out of fear that their political opinion, which is a political opinion held by, presumably half the country, will cause them to be terminated. Maybe they'll get to speak if this declaratory relief is granted. So declaratory judgment is necessary and proper in that plaintiffs in the subclasses contend that Google has committed and continues to commit the violations set forth above. This would be the unfair employment practices. And on information and belief, Google will deny that it has done so. Obviously, Google is going to deny that it has done so because to admit that it has done so will open them up to, an extreme amount of liability. And or will continue to commit such acts. And that is likely... this is likely true, right? Why would they change until they're told they're wrong? I mean, maybe they will. It's just unlikely. Wherefore. So this is the prayer for relief. This is the end of the document. For video viewers of the lawsuit videos that I've done, this is where the prayer for relief comes in. Notice it's not in every cause of action. The prayer for relief comes at the end. Wherefore, plaintiffs on behalf of themselves and all others similarly situated respectfully pray for relief and judgment against defendants, jointly and severally, as follows in amounts according to proof. 1. For an order certifying this action as a class action. So that's the first thing they're asking for. Certify the class, please. Find that all these people are similarly situated. Caucasian, males, right-leaning. These are all subclasses. Some people will be a member of one of any of those subclasses. Other people will be a member of 2 or all 3 of those subclasses. Certify the classes to make this class action. So for an order appointing plaintiffs as class subclass representatives and appointing plaintiffs counsel as class subclass counsel. So if there are other similar actions against Google, they would be consolidated into this class action. The 2 people, Damore and Gudeman, will be representatives. Being the representative in a class action means you get more money than the rest. And there are certain requirements for doing so. And the benefit to not being a representative, and this is the part of it, right, is that the representatives are named. They're exposed to the most amount of public scrutiny. If you're just a white Caucasian Trump supporter who works at Google, you're in these classes. You don't have to do much of anything. You don't have to expose yourself as a member of this class to participate in the lawsuit. Damore and Gudeman had to suffer in advance, so they get a little bit extra attention as the representatives, and therefore they get a little extra compensation if they win. And appointing plaintiffs' counsel as class subclass counsel, because obviously you're suing Google in a class action that's worth millions. You want to be the plaintiff's counsel on that. And you don't want some other schmuck coming in and taking over. Obviously, they want to find for judgment in favor of plaintiffs against defendants. Also in favor of plaintiffs who are tasty. They want preliminary and permanent injunctive relief, enjoining Google from violating California Labor Code Section 1101 and 1102 by discriminating, harassing, and retaliating against individuals with conservative political views. They want the court to specifically say, knock it off. You have to stop this by force of law, and if you continue to do this, you're violating court orders in addition to the law. That's bad. They want declaratory relief. So they want, again, going back to what that declaratory relief is, they want the court to state the specific things that Google must and must not do. We want them to prevent harassment against these people. We want them to not fire these people when they mention something might be illegal. Whatever that may be. For general, special, and compensatory damages, this is money. This is a lot of money in this case. For prejudgment interest, where allowed in an amount according to proof. This is for interest on the amounts prior to judgment, not just earning interest on the amounts following judgment. This is recognizing that the harm was suffered at a prior date, and they want interest from the date of the harm, not from the date of the judgment. Or at least from the date of the filing here. They want, and if you think about it, this could go on for 1 to 2 years. Let's say that the damage award is $10 million and you have 2 years of interest building up. That's a significant amount of money. For attorney's fees under applicable provisions of law, including but not limited to these codes, they lay those out in all of the cause of action. For costs of suit incurred herein, these are court fees. And for such other and further relief as the court deems just and proper. It's from the Dillon Law Group. This is signed by Harmeet K. Dillon. It's not signed, but the other people on this are Ravdeep S. Grewal, Gregory R. Michael. They demand a jury trial for all claims. So that's good. And then that's the end of the complaint. And that's where I'm going to stop tonight. Tomorrow night, or tonight to me, but it's really morning. I'm going to stop that this Friday morning. Friday night, 10:30 p.m. Central. Oh my gosh. Anyone who's still watching, please come to the live stream. It'll be a blast. Make a drinking game out of all of my idiosyncrasies. That's great. Or just grab a glass of whiskey or a beer or whatever you want. sit down and enjoy. Engage in the chat. Hopefully there will be a lot of people. Last one I did had lots of people, and the chat was pretty active. And ask me your questions. Send me your praise. Send me your criticisms. Call me a dummy. Go ahead. That'll be fun. Just come, watch, participate. Let's figure this stuff out together. We're going to start right here going into Damore's memo. Google's ideological echo chamber. Not a loaded title at all, Damore. I love it. It's Exhibit A. We will proceed through other exhibits if we're still going, but the goal will be to get through Exhibit A. It is 8 pages. I'm hoping that a couple hours will be sufficient. Other than that, thanks for watching this. If you find this interesting, share it, like it, subscribe to my channel. I do this kind of stuff more and more, and check me out on Patreon. You don't have to give me any money to check me out on Patreon. You can find audio of all of the episodes on Patreon. You can engage with my supporters, my specific supporters who I appreciate. Check out the rewards. Maybe you want to give me money. Maybe you want to participate in live chats that we do on Wednesdays. Maybe you want to participate in playing a video game with me and having legal questions answered. That could be fun. And then, I provide you with the recording of it. Maybe you want to hear bedtime stories from based Americans, which I read inspirational speeches or writings from historical Americans. Maybe you want to enjoy that stuff, and if you do, toss me some Patreon money, and that'd be great. I really appreciate it. The more Patreon support I get, the more of this stuff I'm able to do. If you like this content, donate. If you can't donate, I get it. No judgment there. But share it. Just share it with people. Share it inside Google. And get called like a racist hate monger or whatever, because you shared a video where someone reads a document and has a couple opinions about it. So whatever, share it around, like it, favorite, engage me in the comments, look me up on every stinking social media platform on earth, I guess, and let's have fun with some of this stuff. It's real people's lives involved, but it's not our lives involved, and we can have some serious and comedic discussion about that. We can empathize with people in bad situations, but we can also laugh at some of the lunacy that's happening. And I mean, some of this stuff is just ridiculous. So yeah, thanks for watching, guys. I'm gonna go pass out because I am dead tired, and I have some fun legal work to do tomorrow morning. So thanks for watching again. Said that 50 times. I gotta stop thanking you, but thank you. You guys, even just watching this makes it so fun for me to do, and I hope you get some entertainment out of it as well. Peace.